with us at some point during this meeting. We are joined by three friends from the Environment and Transportation Committee, Delegates Holmes, Stewart, and Jacobs. And on the task force presentation panel, we have Rena Shaw, Melissa Chiesera, and Deb Seltzer, Chair of the Access to Counsel and Evictions Task Force, Pro Bono Resource Center, and Maryland Legal Services Corporation, respectively. They have also a visual presentation, but whoever would like to go first, we are ready for you.
Great. Thank you so much, Vice Chair Moon, and thank you to the committee for inviting us to do this briefing. My name is Rena Shah. I'm the Executive Director of the Maryland Access to Justice Commission, which is an independent organization powered by the Maryland State Bar Association. I was also the Chair of the Access to Counsel and Evictions Task Force. I'm going to start by walking you through sort of what the Access to Counsel and Evictions law entails. The law was passed during the 2021 legislative session, and it took effect in October of 2021. And what it provides is a right to access counsel, that all Marylanders who income qualify shall have access to legal representation in judicial or administrative proceeding to evict or terminate a tenancy or housing subsidy. This is a game changer. This is a powerful tool, and we will talk about what it means to implement it effectively in Maryland. The Maryland Legal Services Corporation, whose ED is here, does have the responsibility to implement and administer the program, and we expect it to be fully phased by October of 2025. There are a couple of other things that the law created. One was an Access to Counsel and Evictions Fund. It also created the task force, and it also mandated a 10-day pre-filing notice. So the task force, just a little bit about it. There's 15 members. There's representatives from a broad cross-section, including tenants and landlords. It's chaired, the chair was chosen by the Attorney General, and it's staffed by the Office of the Attorney General. And the role of the task force really is to evaluate the services provided through this program and law, to study the potential funding sources, and to make recommendations for improvement of implementation of the program, including any policy or statutory changes. There is a report requirement, annual report in January of each year. So in terms of, I want to start, kind of from the need for the law. We already have the law, but it might be important for us to just remember why it was so important to pass this law and why it'll be important to continue funding it. First, Maryland is unique in that it has a very high number of case filings. I'm specifically talking about in this chart, failure to pay rent case filings, but there are, of course, other landlord-tenant cases. So this is pre-pandemic numbers, but there were about 674,000 cases, individual cases in court related to failure to pay rent. And at that time, there were about 800,000 renters. So the ratio between the rent filings and renters, we were way far ahead in comparison to other states. And so we are a little bit out of line. And so that was one of the reasons that we were so concerned about sort of the tsunami of evictions that could happen. So the other part is also that the filings are, in comparison to the actual evictions, are quite different. So if you have about 674,000 filings, there were about 21,000 evictions. And you'll see in this chart where in terms of dismissals, there were about 158,000 dismissals, and there were about 234,000 warrants. And one of the reasons that Maryland has such a different in terms of what is filed and the folks that are evicted is because we do have this thing called the right to redeem, which allows tenants to, for up to 3 times if they have a judgment in court, to pay and stay. It makes our state unique, but it also causes this astronomical number of filings. Another reason for the law is that, evictions are considered a public health issue. It really came out during COVID, but even before that, there was literature about how evictions can have an impact on health and specifically public health. And so there was a lot of sort of writing and research done during the time of COVID that, it was exacerbating sort of COVID infections, and so that was one other reason for the law. When we think about evictions, obviously we think, of course, a person loses their home. And that is one consequence. Obviously, there's going to be a direct impact on that individual. There's going to be a direct impact on that family. But really, there's so many other things that happen when you lose your home. So the collateral consequences that flow from eviction, it places an economic burden on both the landlords and the tenants. It hurts future employment prospects for tenants and also housing prospects for them to get rehoused. There's literature and research that's been done that links evictions to physical and mental health issues, including depression and suicide. And in children, it really affects educational outcomes, lower school performance, and increases behavioral challenges. In terms of the impact of evictions on Marylanders, there's a disproportionate impact on women and persons of color and communities of color, especially Black women. There was a book that was written a few years ago by the Pulitzer Prize-winning author Matthew Desmond that essentially said that eviction is to women as mass incarceration is to men. Essentially saying that, in these vulnerable communities, the men are getting locked up, but the women are getting locked out. And then in 2020, there was a Baltimore City study that found, in fact, that the number of Black-headed female households had a 296% a greater chance of being sort of evicted than those who are headed by white males. So that disparate impact is quite obvious, and the numbers sort of bear that out. An additional reason for the law is that evictions are costly to the state. So it costs the state a lot of money to evict people, but then also deal with the after effects of evictions. So the law enforcement costs, the shelter costs, healthcare costs, transporting homeless children, foster care costs. So there have been studies that are done that have sort of kind of captured these costs, and in the end, the analysis is that it was more cost effective to invest in the front end with attorneys, providing people with attorneys rather than having people deal with these extraneous costs after the fact. And then, sort of kind of coming to a close, eviction is a legal process. It's not something that should or happen outside the court system. And so people have to go through the court process in order for a landlord to get the warrant to evict someone. However, the gap in knowledge between landlords and tenants about the laws and the court process is quite different, and there's a great knowledge gap where tenants, there's about 1% of tenants at that time who were represented, and over 96% of landlords who had some type of legal or other kind of representation in court. And so there was just a huge knowledge gap, a huge gap in terms of access to legal representation, and in terms of the complexity of case, especially if you could qualify for federal assistance, you're looking at federal, state, local contract and case law that you would have to sort of bring into your case. And so, the conclusion is that access to counsel, right to counsel was sought and as a proven means. It was implemented in other states and other jurisdictions, and it was thought to be a proven means to, forestall eviction, avoid disruptive displacement, and help families. And there are studies from other states that sort of confirm that you can have huge gains, a drop in evictions and people staying housed. At this time, I want to pass it to my colleague, Melissa Chisera from the Pro Bono Research Center, to talk about her experience as an attorney representing people in court.
Thank you. Yeah, so I'm an attorney with the Pro Bono Resource Center, and we're a grantee of this ACE funding. Because we were working in eviction cases prior to the ACE funding, we were able to quickly make great use of these dollars. And we expanded the types of housing cases that we handle, and we expanded our staff. As a result of that, we have more than tripled the number of Maryland tenants that we've been able to assist. In fact, in the first 2 quarters of fiscal year 23, we've represented almost 1,000 Maryland tenants. It's important. Why having an attorney is important for tenants, I think, is going to be best explained by a short video that we have that is actually one of our clients describing her experience in court with one of our attorneys.
I really didn't know what to expect. So where I'm living, I've been there at least going on 10 years, and I've never had to come to court.
So today I had a chance to meet with a pro bono attorney. Honestly, I really didn't understand the process. I wasn't really sure what was going to occur if I was going to be having to deal with eviction. The attorney definitely explained the process to me. The end result of my case is that it was dismissed. It would not have happened if I didn't have that pro bono attorney.
So this client actually highlights a couple of the reasons why having counsel in eviction work is important. She ended up getting a dismissal. So yes, sometimes we really work the magic and find defenses that they otherwise would not know about and can completely prevent an eviction. Other times we assist in negotiating a settlement. Sometimes it's through a payment plan so they can get current with their rent. Other times it's as simple as just negotiating a mutually agreeable date in which they move out, and that allows them enough time to find new housing. And it's a less stressful termination of the landlord-tenant relationship. The other thing she brought up is how much she didn't understand the process. And as we all know, evictions in Maryland is a legal process. And I see all the time in court, tenants coming in and standing in front of a judge asking questions like, what is the next steps? What does the law say? What are my rights? And this really puts judges in a predicament. They're not allowed to give legal advice. But yet here they are with a litigant in front of them who's clearly confused, afraid, and not understanding the process. Allowing tenants to have access to counsel takes this off the judge's plate. They know then the litigants in their courtroom understand what was happening and had fair representation. The other thing to also keep in mind with regard to having access to counsel in eviction work is there's very few private attorneys that do this kind of work on tenant behalf. There's plenty of landlord attorneys, but there's just not very many out there for tenants. And the few that are out there, they're highly selective with the types of cases that they take. And so organizations like mine are there to fill in these gaps. And I'd just like to quickly share a story of an actual client that we're working with right now where we are filling in the gap. It's an illegal eviction case. It's a family, a Baltimore City family. It's 2 parents and several school-age children that live in the home. They had lived in the home for about 5 years with a valid lease. They were current on the rent. But what they didn't know is that the owner of the home fell into Baltimore City tax sale and lost the property. So one day last summer, there was a knock on the door, and it was a man saying, "I'm your new owner, you need to vacate in 30 days. He showed no documentation that proved he owned the house. There was no court summons, there was no court order, none of that. So understandably, they thought it was a scam, and they did not vacate until like a month or so later. They get a call from a frantic neighbor saying, somebody just broke through your door and they're carrying all your belongings out of the house. They call 911 and immediately go back to the property. And on site are multiple people removing all of their belongings. And the police intervene, and the new owner's present, and the police demand to see proof of ownership, which he does. And so then our clients show, well, but we have a valid lease that would have been assumed when he purchased the house. The police immediately throw up their hands and say, this is a civil matter, bye-bye. not our problem. And to make a long story short, our clients tried negotiating, begging, pleading, everything they possibly could to get back access to their home and recover some of their possessions. But the bottom line is this new owner was in it for the purpose of flipping the house, and he wanted to demo it. And so he had already hired some kids off the street. And as they stood there, they're just grabbing electronics, walking away with it. Things are being destroyed. Wires are coming out of the ceiling. The house was uninhabitable. They couldn't. They had to stay in a hotel for quite some time. And they literally had no one to turn to. The police wouldn't help. They couldn't find an attorney to represent them in this. And they lost everything. All their personal possessions, everything of sentimental value. Their grandmother's ashes were destroyed. Jewelry handed down from her mother was gone. Those old, remember back in the day, like people would take movie cameras on those reels of film, all destroyed. They had a bunch of that. And baby pictures, birth certificates. Just imagine living in a place for 5 years, how much you accumulate, and to have it all just be destroyed and nobody even care. So you can imagine how much it meant to them to find our organization and to have us say, you know what, we're going to help you hold this person accountable for what he did to you. And so that's why we're so very grateful for this ACE funding. Thank you.
So I am now going to transition into talking about the report itself and the work of the task force. The task force, we met during the fall of this year to release our report at the end of December, and we heard a lot of stories like this from legal services organizations. And we heard from other stakeholders, including the Judiciary, DHCD, MLSC, the legal service providers. So we had, a lot of stakeholders come in and let us know how implementation is going. One other thing we learned about was that nationally, when Maryland passed this law, we were the second state in the nation to have the statewide access to counsel. But now, during COVID, there was a lot of federal money flowing into states. And in fact, we are part of this larger national movement. And so there have been 3 states that now have a right or access to counsel, 15 cities. And then 60 other cities have expanded their legal representation using the Emergency Rental Assistance Fund. So this was something that, was like a good use and was promoted by the federal government as well. So I want to catch you all up in terms of the current status of eviction in Maryland. I started off by giving you the pre-pandemic numbers, and we were around 674,000-ish. We only have data between January and September of 2022, so we don't have all the data from the Judiciary for the remainder of 2022 yet. However, there were around 244,000 filings and about 8,800 evictions in that 9-month span in 2022. You can see on the screen that in terms of the numbers, we are, 2019 is in red, and those numbers are quite high, and we remain sort of below those, pre-pandemic numbers. However, evictions are inching up. So pre-pandemic, we were at 21,000 evictions for the whole year. And even though filings are down, almost by a difference of almost 400,000, the evictions, the difference is, almost 9,000 to 21,000. So that ratio is not the same. So the evictions are sort of kind of spiking back up, obviously slower than they were before. The other thing we want to point out is the Access to Justice Commission has done these sort of maps to help us visualize where evictions are happening in the state. And you can see that evictions are not just an urban issue or a rural issue. They're happening all over the state. And, in terms of the filings, Baltimore County and Prince George's County are sort of sticking out as the high kind of volume places. But in terms of eviction, you see other counties, Baltimore County, but also Washington County, sort of more out west, Dorchester County, Harford County, Cecil County. So these are happening all over the state, and there's a kind of a visualization where you can compare and click on to get to know the exact numbers in the county. The status of rental assistance in Maryland, I believe the ENT committee recently had a briefing with DHCD, but we just wanted to briefly mention it here as well, that they are anticipating that 100% of all programs, the county programs, will conclude by March or April of this year. And in terms of who they've assisted, so they've been able to assist over 101,000 households. And interestingly, their numbers, which are up to November 2022, showed that the people who received rental assistance, 71% were female and 74% were Black. So it really tracks with what we were seeing with the other studies, where it is Black and women are sort of the key cohort that are facing this crisis. At this time, let me hand it over to my colleague, Deb Seltzer from the Maryland Legal Services Corporation, to talk about the status of the implementation of the program and also funding.
Thanks, Rena. My name is Deb Seltzer. I'm the Executive Director of Maryland Legal Services Corporation. We are a legislatively created nonprofit. We were created in 1982 to raise and administer funding for civil legal aid across the entire state. So we were named as the administrator of the Access to Counsel and Evictions program in the original law. I'm going to go through some things that have happened this year and also some planning for next year. So we received the details of the funding for FY23 in the late summer and early fall of 2022. We had two major funding sources for the Access to Counsel and Evictions program. That was a state appropriation, as well as funding through the Department of Housing and Community Development through that emergency rental assistance program, because there were housing stability services that were eligible through that program. Separately from ACE, but at the same time, we are also working with Baltimore City. They passed their own right to counsel in evictions ordinance, so it is kind of a complement to the statewide legislation. The state legislation also requires us to prioritize jurisdictions who have put up their own money or their own statutes for access to counsel. So we are running some Baltimore City programs with Baltimore City specific funding. Their ordinance is slightly different in terms of case types and things that are covered under it, but it is a complement to ACE and also supported by ACE funding. So we made legal services grants for phase 1 jurisdictions, and again, we prioritized those jurisdictions who had significant funding of their own in the past towards legal services, and that's Anne Arundel County, Baltimore City, Baltimore County, Frederick, Montgomery, Prince George's, and the 5 midshore counties, which are Caroline, Dorchester, Kent, Queen Anne's, and Talbot. So we made grants to 8 legal services providers, all of whom had deep experience doing eviction prevention work. These were not kind of new startup organizations just getting involved here. These were organizations who were very experienced and familiar with this work so that they were able to jump right in and expand the work that they were already doing. However, what we found is that as you probably all know, the tight labor market also affected many nonprofit organizations, and many of our grantees had a difficult time hiring up. So even though the funding was available by the fall, it has taken the past few months for them to be able to get up to speed in terms of a full staffing level. And in fact, some organizations are still hiring attorneys, paralegals, and administrators for this program. But in the meantime, they have continued to do the work that they've been doing and are working to serve as many tenants as possible. In September, we held a symposium for the legal services providers to provide a full day of training. We had a plenary session on racial equity. We had panels of judges and tenants and break out some substantive law issues that were tailored to each attendee's experience level in landlord-tenant law. We had Demetria McCain, who is the Principal Deputy Assistant Secretary for Fair Housing and Equal Opportunity at HUD, was our lunchtime keynote speaker. And we had approximately 100 legal services attorneys, law students, and pro bono attorneys from across the state who attended. One key aspect of ACE that will be a major change for the legal services providers is that we are working to set up a coordinated intake system so that there will be one phone number and one website for tenants, as opposed to them receiving a list of providers who they would have to call individually to find help. So we are working with the United Way of Central Maryland, who runs the 211 program. You may be familiar with 211, where people can call and kind of get information and referral for a wide range of services. They have, many years of experience of doing this kind of work and some experience with doing this more established intake, more in-depth intake for other programs. They are working with Civil Justice, a provider who has a lot of experience in legal tech, and a company called A2J Tech, which has coordinated intake systems running in Minnesota and Washington, D.C. We have started contracting for evaluation of the program. Right now, we are working with Stout Rishis Ross, who is doing also evaluations in Cleveland, Milwaukee, and the state of Connecticut. And they have a lot of experience in this area. They are working right now on data collection and what the providers will need to collect to do a robust evaluation. We're also working with the Schaefer Center at the University of Baltimore to conduct tenant focus groups from across the state to ensure that the tenant voice is heard about how they experience the process. The Access to Counsel and Evictions law required us to create brochures that talked about the program and tenants' rights. So we are coordinating with sheriffs and constables' office from across the state. They are now distributing that in almost all jurisdictions with the summons to court. So every tenant who gets a summons to court should also be receiving that brochure. And as I said, there's one more jurisdiction that we're still coordinating delivery of those brochures, but those should be going out soon. We'll also be updating those brochures as implementation of the program progresses. So for example, we are actually about to do a round of edits. Even though coordinated intake is not yet fully functional, 211 has agreed to serve as a referral provider that will help match tenants with providers in their jurisdiction. So looking forward to next year, we're going to be expanding the legal services into what we're calling phase 2, which would be all the remaining Maryland jurisdictions. We'll have the coordinated intake launch in Baltimore City first, so we can make sure that everything is running smoothly, and then followed by the phase 1 jurisdictions. We're also going to be expanding tenant outreach and education, which is required by the law. We will be contracting probably at the end of this fiscal year with community groups. So not necessarily legal services providers, but the folks who are on the ground working with tenants daily, making sure that they know that these services are available. And then the evaluation will continue and will be iterative, so they can kind of get instant feedback. Providers can get instant feedback, and also will be able to compare across jurisdictions to see how services are going. Right now, in many jurisdictions, services are available both through what we call pre-trial intake, where a client is connected with the legal services provider before the day of trial. They can do discovery, they can work on getting all the fact finding done. But we also have in many jurisdictions same-day service. So a tenant may not know that lawyers are available, but once they get to court, there may be a sign, there may be an announcement that says, a lawyer is available if you would like to speak to them. So our income eligibility guidelines, every piece of funding that flows through MLSC has a restriction of 50% of Maryland median income. So far we have found, virtually all tenants fall within that are facing eviction have fallen within that income eligibility. So looking quickly at funding for next year, we have 2 pieces of funding that we know are coming. We have $14 million that will be coming from the Abandoned Property Fund, thanks to legislation from last year. Also, legislation from last year implemented a program where any consumer protection recoveries from the Attorney General's office that are related to rental housing will go into the Access to Counsel and Eviction Special Fund. So total, we know next year coming, we will have $16.45 million. We will also, some of the funding that we received this year is multi-year and will continue and carry over into next year. In terms of expenses, we are looking to significantly expand legal services, as I said, both within the current jurisdictions and beyond into the other jurisdictions. We'll be beefing out coordinated intake more, as well as the tenant outreach and education. So we are looking at expenditures of almost $19 million. Because of that carryover funding, we know that we should be all set for next year. However, there is no funding identified so far for after next year. There's no funding for FY25 and beyond. And as Rena mentioned earlier, the goal for full implementation is October 1st of 2025. But continued funding will obviously be necessary to make that a reality.
So I'm going to transition now into sort of going through how the task force, the key issues that came up in the task force and the recommendations that were made by the task force this year for their 2023 report. I want to start with some principles that the task force in their roadmap report. So the first report was last year. It was delivered in January of 2022. What the task force at that time sort of put together is, yes, there's going to be year over year, we're going to have different sort of policy changes or things that we want to raise, but we want to have a set of guiding principles that we follow in the implementation of this program that really was led by the reason to have this program in the first place. And some of the key tenets of these guiding principles, I think it's important to share because it'll help sort of understand the recommendations as well. First, that income eligible tenants shall have access to counsel and eviction proceedings, and this does not mean that maybe they will or maybe they won't. It means that they shall have it and it shall be meaningful. So for us to say that if they have this right to access counsel, it has to be meaningful, and we have to put things in place in order for them, in order for tenants, in order for Marylanders to actually access that counsel. We also wanted to keep equity at the forefront. I said at the outset that there are disparate impact. Certain communities, certain populations are impacted more than others. And so we wanted to make sure that we are designing programs that keep equity at the forefront of outreach, implementation, and evaluation, so each step of the process. We want to build a system that is fair, accessible, understood, and easily navigable. In all honesty, for tenants and Marylanders seeking assistance, it can be quite complicated to even figure out the system of assistance. And so we wanted to use this opportunity to design something that would actually make it easier for people to receive help. We also wanted to reach tenants at the earliest possible phase, and there was broad consensus from landlords, from all of the other folks on the task force, that reaching people early mattered, and it would make an impact to make sure that people don't go in that spiral. And then we also wanted to ensure, because this is a new law, because it is statewide, and we understand that there are differences across the jurisdictions, especially in the courts and maybe processes and procedures that are in place with rental assistance, with many other things. But we wanted this to feel like a statewide law and ensure that there would be consistency and uniformity of experience, no matter where you are in that state. So everyone could feel that they're having that meaningful access to representation. I'm going to now go through some of the key recommendations, and you'll have in this PowerPoint sort of all the recommendations that we have in the report, but I do want to take the opportunity to highlight those that, directly, obviously, that you all could have some say in or, could do some work around. So I'm actually going to ask Deb if we can skip to the second to last slide, which has to do with funding. So when Deb Seltzer gave her report, we do not have funding for FY25. So we have sufficient funding for FY24, but we do not have funding moving forward. When the law was passed in 2021, at that time the law was passed without any funding. So last year, we were before you all to really say, we need to start this program up, we need to implement this program, we need funding. And at that time, the legislature and also the governor were able to put in sufficient funding for us to come out with 2 years of funding, 2 years of startup funding. But at this point, I think, hiring has commenced, we're building infrastructure in these organizations, and what we need is sort of a constant and stable source of funding. And so there's different options, but the task force really thought that a line item in the budget may be sort of the gold standard for this kind of funding, so it's a dedicated source of funding. Last year, the abandoned property fund was used as a source of funding as well. However, there's a 1-year restriction on that $14 million. So another way is to be able to lift that restriction on the abandoned property fund funding to say there could be continuing funding through that. And so, there's an opportunity. Obviously, things are going to be evaluated. As Deb said, we've hired sort of folks that are going to do the evaluation. There will be a recalculation in terms of need year over year. But, in terms of trying to figure out a stable source of funding, I think that's our key sort of recommendation coming out of the task force. I'm going to go backwards now and go into some of the other recommendations. As Deb said, MLSC is going to be investing more in terms of outreach and evaluation. And as we mentioned, we want early outreach to be sort of a key here. And so we thought there could be more integration with data and with communications to make sure people out there know. And I believe some of the steps that were recommended in the task force MLSC has already implemented, including making 211 that number for all phase 1 jurisdictions, which is great to sort of see. Now, in terms of something that I mentioned briefly at the outset, one of the things that this law covered is having a 10-day notice, pre-filing notice as part of this law. And what we heard from stakeholders was that we see a lot of landlords not using the form that has been that the court has created. And so there's kind of a missed opportunity there, and it's not according to what the law sort of says should be done. That form needs to be used by landlords, and that form also includes with it the list of legal services organization, kind of notice of this access to counsel. And so if people are making up their own forms, it could be problematic. And so one of the, recommendations was for either the Judiciary or the General Assembly to create some uniformity through a court rule or legislative reform to reflect that if there's failure to produce proof of that 10-day pre-filing notice, and if there's, not use of the proper form, that it could be grounds for dismissal. Because I think that was the intent of the form, to make sure that those are used as a way to sort of ward off the filing and then subsequent eviction. The next slide deals with this, having a coordinated intake, which Deb has already talked about, and that they are going to use 211 as the single sort of place to have, anyone who needs help go to, which will be very helpful instead of a list of different numbers, which could become confusing. Another area that there was a lot of discussion around, and is ripe for discussion here as well, it has to do with uniformity of court rules and procedures. There was efforts through the Judiciary Rules Committee. During the task force, there was a lot of sort of discussion about what are the steps. So we are trying to get information out to tenants as early as possible. But as the system exists right now, a lot of people first learn that they could have a right to counsel or they could access counsel even before this law when they come to court. They might not receive it beforehand. And so if they come to court and that's the first time that they are sort of getting this information that they have it, then there are a few things that the court could actually do to meaningfully help implement this law, including inform people. Every judge has something that they say in the beginning, incorporate sort of the fact that there is an ACE law, that people have a right to access counsel. That could be incorporated into their colloquy. When tenants are called before there's a default judgment, there could also be, an announcement with the property address and name, because that's not done, in all the jurisdictions. To make sure that people don't get default judgments without them knowing that their case was called. Also, there was suggestion in terms of recess to if someone says I want to connect with counsel that's outside in the hallway and available in court, wanted to make sure the court was able to give a recess for those tenants to kind of receive counsel and advice while they're there. But sometimes we know that, you might need sort of paperwork and you might need more information, et cetera. And so it's possible that a postponement is required to meaningfully access counsel. And so that was another thing that was discussed in terms of potentially having a 10-day postponement or some sort of set postponement that could, be instituted if a tenant sort of requested it in order to meaningfully access counsel. So the recommendation that came out of this whole discussion is to create some uniformity in recesses and postponements through court rule or legislative reform to ensure meaningful access to counsel. The other area that Deb sort of covered was that, one of our key recommendations in our first report, the roadmap report we call it, is to provide adequate staff, including attorneys and paralegals and other staff, because if you don't have staff, you cannot implement this program and you cannot get the benefits from the program. And as she mentioned, it has been very challenging to recruit attorneys. And part of the reason is that civil legal aid organizations are probably the least sort of like when you think of the public interest, so we're not comparing to private attorneys, obviously that's a whole different game, but when you're comparing to other public interest organizations, civil legal aid organization salaries are quite, there's a significant gap in those salaries. So what I know is between the, let's say, starting salary of a public defender and a legal aid organization, there's at least a $20,000 gap. And so recruitment is hard, and we need to address that. Otherwise, we won't have the people in place to be able to do that work. And so there was a recommendation to address that pay issue for the ACE attorneys. Another part of this work is data. Another big part. So last year when we were here, we also passed an eviction data law that goes into effect January of this year. And the data, the eviction data, and some more data that the judiciary generally does not publicize will be collected by the judiciary and sent over to DHCD for DHCD to create a real-time eviction data hub and to include an equity analysis. So we really know, are we kind of reaching the right people? Are we, being effective with this law? And so there are going to be challenges with this because we know that part of the judiciary, a lot of their data is still, a lot of their cases, especially in Baltimore City, is still manual. And so, that's going to be an issue that we have to continue contending with, but the data is really important to the implementation of this program and the evaluation of this program. So that's something that we're going to have to keep monitoring. I already covered sort of the key recommendation having to do with funding, but I'll reiterate it again and end on that note. I think this year we are here in the legislature, the task force, requests that the legislature really look at the benefits that this program can have on Marylanders, especially vulnerable Marylanders, and really think about future continuous, stable, and state funding to fund the access to counsel in evictions law. I'll conclude there. Thank you so much for your time.
All right, thank you for that update. We have two questions. We'll start with Delegate Kaufman and then Delegate Simpson. Excuse me, and from our friends in ENT, Delegate Holmes.
Yes, thank you. I really think that this, let me take my mask off so it's a little easier to hear me. I really think you guys are doing God's work, so thank you for everything you do. I was struck by and troubled by two things in your PowerPoint. One thing where you said 3 in 4 of the folks that you came across didn't know they could raise a legal defense to eviction based on serious defects in their homes. And then also you had said that 60% of defendants could have raised a conditions-based defense, but only 8% were successful in doing so. So my question is, for the first part, with folks not knowing that they could raise a legal defense to eviction based on serious defects in their home, is there anything that the General Assembly could do for for public education on that? And also, what do you attribute such a low success rate for the 8%? Is it pro se representation or judicial bias? And then my other question, very briefly, Mr. Vice Chair, is that a lot of these recommendations I think are excellent, but I think a lot of landlords would bristle at them. So do you have any landlords on your on the panel, on your task force? Because I think you'll have more buy-in if you have landlords saying, yeah, I'm a landlord, but I believe in this thing.
Let me take the second question first. So we absolutely did have landlords. We have 2 landlord representatives on the task force that are heavily active and are participating in these conversations and providing great suggestions. I will point out that, interestingly, there was a lot of common ground with landlords. Of course, there were things that there were disagreements about, but there are also a lot of landlords who think that having the representation is helpful and can help with efficiency in court and help kind of help the process move along more smoothly. So we definitely have that input on the task force, and it has been integrated there. I can start answering the other question in regards to the 3 and 4 and the 60%, but I would welcome if others want to jump in on that one. So this is a study that the Public Justice Center did a few years ago. And essentially, I think there is what we were talking about in terms of this knowledge gap. What we find is that obviously there's great laws on the books, but if people don't know about those laws, they are not going to be able to raise them in a court of law. First of all, it's kind of intimidating. They're maybe there for the first time. The jargon is challenging. The process is challenging. But then to be able to kind of say, okay, this is actually a defense to my rent court action is challenging. So I think what these numbers are showing is that people don't know that there are legal remedies. There are legal defenses. Oftentimes people say, oh, it's a rent court action, so the only question should be, do you owe the rent or not? In fact, there's complexity there, because you could say, I owe the rent, but I also have vermin and I also don't have heat, and that is an actual defense to that action. And so I don't think enough people are aware of that, and therefore they cannot raise it. I think the 8% number compared to the 60% number is saying that while more people had the ability to raise the defense, when they were representing themselves, really very few people actually were able to do it on their own.
And I actually would agree with that. There is a knowledge gap. Tenants don't necessarily realize the escrow law. However, instinctively, when they are living in these conditions, they think, my landlord doesn't deserve this money, and they will withhold, which is what ultimately gets them into failure to pay rent court. Unfortunately, some of them don't just bank it, they've spent it already, and then the judge requires a funding of the escrow account in some cases immediately, like that day, and so that can be prohibitive as well. Another issue that some of the tenants encounter, like in the jurisdiction of Baltimore County, that escrow law has a notice requirement that is very challenging for tenants to meet. They will not accept actual notice. So typically, how landlords and tenants communicate these days is via text. There's a lot of that, and so these conditions will. The tenant will notify the landlord of the conditions via a text message. Baltimore County won't accept that as being put on notice of a condition that needs to be repaired, and so a lot of tenants get stopped in their escrow attempts at that point. I will say, in my experience, a lot of the judges are good right now about indicating in the failure to pay rent court that conditions of the property is a defense. I mean, they are making folks aware to some extent. It just, those next steps of how to get to escrow usually are prohibitive, and that is truly where an attorney can make a difference. There are times where we can make arguments right in the failure to pay rent context of abating some of the rent so that they don't have to fund so much into the escrow account, and that is something that a tenant definitely is not equipped to do on their own.
All right, so we're gonna go Delegate Simpson, Holmes, and then Young, and I just want folks to be mindful that people are beginning to file in for 3 o'clock bill hearings, but we started a little bit late, so we can hold over a bit. So go ahead, Delegate Simpson.
I think you probably said it, but I missed it. So how many have you served, or how many do you serve in a year?
The statistic that we pulled this morning before I came was for the first 2 quarters of fiscal year 23. So fiscal year 23 started July 1, and we are, I think it was 999 clients we represented. So that doesn't even count like just people we talked to for brief advice on our hotline. Prior to this funding, I think 245 was for like the same period the year before that. Those first 2 quarters was 245. So we tripled.
So what was your fiscal year 22 ending number?
Again, we just compared the 2 quarters, so 6-month period. So in fiscal year, so from July 1 to December 1 of 21, it was 245 tenants we represented. From July 1 of 22 to December 31st of 22, it was 999 tenants we represented.
Delegate Simpson, I can pull stats for you for all of the grantees. There are 8 legal services providers and send them along, and what the comparison was in kind of pre-pandemic times and then to now.
That would be great. Thank you very much. And can we get a copy of the presentation? Oh. Thank you. Been running around.
Thank you, Mr. Chair, Vice Chair. I appreciate the opportunity. By way of introduction, we are on the, 3 of us here are on the Environment and Transportation Subcommittee, and within that committee, there's a Housing and Real Property Subcommittee, of which we are part of. I've got several questions, but because of time, I'll get back to you with others lately. You mentioned the uniformity of court systems. And I'll tell you, when I go to court between Prince George and Charles County, there's a huge difference. Is there a piece of legislation within probably this committee that's looking at uniformity in the court systems? Is there something that someone is looking at legislatively? Not yet. Okay. The other question that I have is in terms of the time frame between filing and the warrant. Is that something that the task force had looked at? Because that time frame has been bantied about for years and years. And I don't know if that's something that you studied yet.
We definitely did look at it, and that's also an issue of, I guess, lack of consistency across jurisdictions. We got feedback from some jurisdictions, for example, Anne Arundel County. I don't know off the top of my head, I don't recall, the exact timing between the failure to pay rent filing and the warrant, but I do know that even in terms of calling the case, in terms of the case coming up after the filing, Anne Arundel County was a week, like to the day, and there were other jurisdictions that took much longer. So there was actually what we learned about, sort of the lack of consistency, the lack of uniformity, also applied to this particular issue. And, I think there's a range. That's what I can say.
And finally, Mr. Vice Chair, the 10-day filing period, the 10-day notice before the filing period, where does that stand right now?
There is a 10-day notice that the landlord is required to give to the tenant, but
It
they
is.
are not required to file it anywhere.
Oh, not required to file it or put it on the filing document is what you're saying?
Correct.
I got it.
Unlike the foreclosure, for example,
That's
notice
correct.
of intent, there's
Yes.
actually a repository of that notice, so it's collected to know that that notice had been filed, and we can use it for other things like analysis of where hotspots are, et cetera. There's no such requirement for this notice.
Thank you, Mr. Vice Chair.
So it is on the complaint, though. They do have to indicate.
Indicate that they
On the
filed it.
complaint itself. Once they file for failure to pay rent, there is a section that they have to complete as to certify when they gave the 10-day notice.
But there's no requirement to attach it.
Correct. Yeah.
Sorry about that. Okay, Delegate Young, then I see Delegate Phillips, Delegate Schmidt.
Thank you, Mr. Chair. Quick question. You talked about the data that you all are looking to provide. Talked about how Baltimore City is manual. Can you elaborate on that?
Yes, so last year, the bill that became law on eviction data, essentially the data that the judiciary currently puts out is limited. So they'll tell you the number of filings, warrants, evictions that happen in each county per month. But there is no sense of, what zip code in that county is a hot spot. Where are most of the evictions happening? So there's not that granular level data. The other issue was that the judiciary, for example, the data that I shared with you for 2022 was January to September, because the judiciary just released that July to September data just in the past few weeks. And so there's a lag between sort of, and it could be that, they release it not necessarily on a month-by-month basis. So what the law did was essentially require there to be more granular reporting so that we could know zip code level data, we could know address data that would be aggregated, obviously wouldn't release it, any personal information, and that we could also sort of, if we know that, then be able to do the equity analysis. And it required reporting on a monthly basis to DHCD. I just talked to DHCD prior to this briefing to sort of understand what that process is. And what our understanding is that the judiciary has interpreted the beginning, in January 2023, for them to start reporting that data to DHCD. So they are anticipating that they will have that data to DHCD by mid-February or late February and move forward. However, we do know that Baltimore City is not on MDEC yet, and they also don't file, sort of like the filing is not in a way that is easily collectible. So a lot of that data has to be entered by clerks manually. And so that's a challenge because, especially in that high volume jurisdiction, a large percent of the cases, so out of the 675,000 that I initially mentioned, 2019, 150 were Baltimore City. So 150,000. So it is challenging. I know that courts are obviously moving towards that system, but there is no such system sort of in place right now. And even with MDEC jurisdictions, it is challenging to collect the kind of data that we are, that would be actually useful for this kind of analysis.
Quick follow-up. Have or could the sheriff's offices be helpful in that?
They are part of the system, absolutely, because it's actually the sheriff's offices, and of course, each sheriff's office collects data differently, has different systems, but they are the ones that actually have the eviction data, and they have to report it back to the judiciary.
I see.
So they are part of the system, yes.
Thank you so much.
Thank you.
I believe it was Ms. Chiasera, right? You shared a story about a tenant that you all are representing who had all of their things. That is one of those classic scenarios, particularly where police officers say, hey, it's a civil matter. Is there a recommendation that you might have? Because that comes up quite frequently, right? Is there a recommendation when people fall into that unfortunate situation, right, where you're looking for help? And
So in Baltimore City, there is law on the books that makes that what happened here a criminal offense. I don't have an answer why the officers felt like they didn't have the power to do anything. It's a misdemeanor. And typically when we have somebody call in and say this is happening to them, we say, call the police. And it's just, I've heard some stories where there are officers that will prevent the changing of locks or anything like that when an illegal eviction is happening. And then sometimes we encounter what happened here. I don't, like I said, there's law on the books. I don't have an answer why.
would there be, if we think about some type of injunctive relief, right? Most tenants aren't equipped, informed, but would there be something that we could suggest that would happen in those situations immediately?
you could go to circuit court for injunctive relief. I mean, that is definitely, that triggers the need for an attorney and quickly. Yeah, and our organization could do something like that. Most of the time, we're not encountering this stuff quick enough. Like in this case, they didn't find us till weeks after this had happened, and the house.
And I guess I'm suggesting maybe there's a process that kicks in when there's a dispute. If the law enforcement officers understand it, they say, look, this is how you have to deal with this.
That would be fantastic, yeah. I think there could be support for something like that. That would be an excellent idea. Instead, like, take everybody down to the commissioner's office, and I think that's a great idea.
Delegate Schmidt.
How many members are on the task force?
15 members.
How many of those 15 members receive state funds?
So I think there are 3 to 4 representative. Who's on the task force is in the statute. So the legal services organizations have a certain number of seats, and so the legal services organizations that are receiving some of the funds under this program have a few of those seats on there.
Is there any third-party oversight to evaluate the task force? Is there anybody who's not receiving funds that pays attention to what the task force is doing?
So the task force is not receiving any funds.
Okay, but
We don't distribute funds either.
But the organizations, so the task force has organizations that receive funds. People that are in the organizations are on the task force that receive the funds. Is that correct?
Right. By statute, there are several seats designated for the legal services organizations.
And is there an open seat for somebody who is not?
The seats are prescriptive, so it's representatives from the State Bar Association, representatives from landlords, representatives from the community groups. So that's, I mean, the seats are spelled out in the statute.
Gotcha. Thank you.
Okay, thank you. I had my questions written down, but then I got out of order, so let me backtrack. I'm more specifically concerned about Prince George's County. We have the highest number of Black people in the state of Maryland in Prince George's County. So I would like to know, first, thank you for your work, and thank you for what you're doing, gathering this data and getting all this information. For us, this is the second time I had a chance to hear this. I would like to know, how are you, so you indicated Black women are the highest number of individuals being evicted. How do you get that data? And I apologize, I trickled in from the state of the state activity. So if you indicated that in the beginning, I apologize. But can you tell me, how do you get that data? And the other part is, how many folks in Prince George's are you helping as it relates to this statewide versus other jurisdictions?
So let me answer the first part.
Sure.
Probably Deb has more insight in the second part. So in terms of the data, there are a couple of places that we are seeing it. So there is, I mentioned the Pulitzer Prize winning author Matthew Desmond. He wrote the book Evicted. And now he also runs the eviction lab at Princeton University. And so they have a database, and they're collecting data from different states. And so they're doing analysis on kind of a national basis. And so part of his analysis also comes to that conclusion where it's Black women that are the most impacted by eviction. So that's one place that we're getting it. The specific number that I cited in my presentation had to do with a study that was done in Baltimore City, where they actually sort of studied, and it was Professor Tim Thomas and others that were involved in that analysis, and they came up with that 296% number. So Black women-headed households were 296% more likely to be evicted than white men-headed households. And that was an analysis specifically done on Baltimore City. So not the whole state, but that one jurisdiction. in terms of Prince George's County?
I can pull the exact numbers and get those to you, but we do have, I think, 3 or 4 different legal services providers who do work in Prince George's County specifically. One of our goals for the program is also to make sure that there are at least 2 providers in every jurisdiction in case there are conflicts, in case there are capacity issues. We want to make sure that there is backup. But there are several general service organizations in Prince George's County, and then we have some of our statewide programs who are experts in particular areas. So for example, Disability Rights Maryland, who will help support evictions that are, related to a tenant's disability. So there is both these kind of general population ones and specific ones, but I'll get you the.
Okay, just a two quick other questions, and you all can get back to me about this. I wanted to know, how are you, again, in Prince George's County, if there's something I need to do to work with you all on this, how are you communicating? And I think Delegate Young indicated that the sheriffs, that was part of my line of questioning, was what are you doing to build that relationship with the sheriff's department? And then when you are in court, do you just, I guess you know who's going to be there based off, information you receive, whether it's on the database or whether it's the sheriffs, that individuals are going to be in court? Do you just stand up and say, hey, I'm here to, help you with your civil issue if they do get called? So what is that process like?
So kind of 2 different levels here. As the statewide funder, MLSC, our interaction with the sheriff has mostly been through the outreach materials, through the brochures that are going out with the summons. The providers who are in court doing the work, and again, we can get you the exact information, but for example, in Prince George's County, a lot of them are wearing, a lanyard of a certain color, or the judge will say at the beginning of the docket, there is an attorney here from, this organization. If you want to go see them over here. So that's something that is happening in Prince George's County. They certainly have a day of court program. And I can have those organizations reach out to you as well for the exact details on how that works.
Okay, that'd be great. I just wanted, if we having an issue, I want to do my part to make sure that we let as many people know that you do exist in the courthouse and they can, reach out to you. So thank you, Mr. Chair.
Delegate Schmidt?
Yeah, one last question I have. The budget last year, $16.5 million, is that correct?
That's for next year.
That's for next year. Okay. I'm showing on Judiciary that evictions are down 30% for third quarter. So is that due to your actions, or?
So evictions are still not back to their pre-pandemic level. So we are still facing, however, what we are finding in many jurisdictions is that more tenants are showing up to court. So one of the charts that Rena showed earlier is that the number of tenants who actually appear has gone up compared to before. So before, there was, in some jurisdictions, only 3 or 4% of tenants would actually show up to their hearing. So now more tenants, potentially because of the 10-day notice, because of the brochure, they are showing up to court.
Yeah, I was going to ask if that new law has helped with that.
Right. So the volume of folks who are actually there is either the same or maybe starting to creep up even higher than the pandemic, even though the filings, you're right, are still at, overall, I think on a year-on-year base, they're still about 55% of what they were in 2019.
Sure. Okay. Thank you.
Delegate Cardin, and then I'm going to say this is the last question because we got to get on with the show.
I wasn't going to ask a question, but since you brought it up, Delegate Schmidt, I just wanted to just confirm. So when we passed this legislation last year, we had testimony from an organization that was working with you. It was excellent. I enjoyed voting for it. That said that you were going to be able to reduce evictions by 80% if the right to counsel was given to everybody. And yet, I'm just hearing now that they're reduced, that you only have about, of the 999 cases, about 22%, 23% ended up in a version of eviction. So how do we manage those? I mean, we're paying a lot of money, which is good. We should pay this money to give this representation. But if we're only getting 23% when we were kind of said, oh yeah, if we can be there, we can help them find a cause of action that can avert the eviction. And we're going to get most of these people to remain in their houses. Where's the inconsistency there?
Yeah, I mean, I'll start, and I just want to, so this 900 number, I just want to make it very clear. This is one organization out of many that receive funding. So I think our colleague Melissa was sharing numbers related specific to her organization. The other piece that we have to remember, and Deb sort of went through it, is that the funding, the law was passed in 2021. We did not have funding until 2022. And even after we received sort of the allocation of funding, we did not actually have the funds to start implementing the program until quite late into 2022. And the evaluation has barely just gotten started. And we mentioned that there are hiring issues. And so what we are reporting right now is not necessarily the numbers. Hopefully by next year, when we have the 1 year of evaluation and implementation, we'll have the numbers of the impact of the program. Right now, we are not able to report that in kind of a meaningful way. But Deb can kind of.
Sure, yeah, so we have started to collect stats. I'm not sure where the 20% number comes from, but the
Thought that I saw that you had 340 eviction aversions in something that I was reading. And I thought that the number was 1,046 was the total number of cases. And
that may be some cases that we had under a certain funding sort. I'm not sure. I can look back into that and go what's into that. But I think Rena is right that we are still really just in the beginning of implementation, and that program hasn't grown enough yet to have kind of a full impact evaluation yet.
And if I could just add real quick, I mean, as talented as all of us attorneys are, we can't always get dismissals. There's other outcomes for these tenants that is something other than a dismissal that are still advantageous to them that they wouldn't be able to get unless they were represented by counsel. And like I said in my spiel, it could be a payment plan, it could be just time to get their life together and find new housing. All of that is still a big advantage to them and less disruptive than the sheriff showing up and changing the locks.
Yeah, and I think the law itself talks about, reducing disruptive displacement specifically because it is a definition that includes, preventing eviction, but also, preventing all of these other sort of other harms that tenants could face.
Okay, thank you all very much for coming and presenting this information to us today. We really appreciate it, and thanks to the members of the Environment and Transportation Committee for joining us today. Committee, we are going to start bill hearings at 3:30 in 10 minutes. We need a little bit of time to let the Zoom kick over, and we'll announce a bill order here shortly. Thank you.